Hi, my name is Meghan Truick, and today we're going to talk about a topic that may be considered morbid by others, but it's very important. Dying intestate. Dying intestate has two sides. You have one side, the person who dies without leaving a will. What does that mean if you do not have a will and you pass? And then dying intestate for that person who you're leaving behind because you did not have a will. And so this video today will address first, what does it mean to die without a will? Dying intestate. When someone dies without a will, if they have assets that require probate, that means you need to go get permission from a court before you can distribute the asset that that person who passed left behind. The court will determine that that person died intestate because one, their will wasn't valid, or two, they totally had no will at all. Both situations will need to be probated. Both situations will need to be taken to the court, and they're basically treated the same. So if you have an invalid will, or whether you have no will at all, you'll be considered to have died intestate. So that person goes to the court, and first you have to decide who are the heirs of that person. So you do a determination of heirship. When you do a determination of heirship, the court is going to look at who are the persons who take from that person's estate. And first today we're going to talk about what happens or who takes under a situation where you're married and you pass intestate. So if you're married and you pass without having a will or having a valid will, and you have no children, then the court will look, one, were they separated at the time? Were the spouses separated at the time when that person passed? Two, did the person enter the marriage with any separate property? Did you enter the marriage with property? And they will look what family members of that person is still alive. So you have no children, you're married, you do have assets, your mother and father are alive, or a parent is alive. Then the court will, of course, say these are the heirs. The heirs will be the husband or the wife, and the heirs will either also be the mother and father or the siblings and or parents of that person who passes. If you pass with children, then the court will decide, okay, you're married, you have children. Is this your first marriage, second marriage? Did you enter the marriage with children? Are these children also the children of the spouse that's alive? If the children are the children of the spouse that's alive, then that's a simpler estate probate. That's a simpler probate of an estate. The court will determine the heirs of that person. So you have the husband or the wife who will be the heirs of the community property, and then you have the children who could also take under a situation. However, if you're married and all the children are your children, then usually the spouse that's alive will take that entire estate. And how the courts look at that, how society looks at that, is that that parent that's alive will have to take care of those children, and therefore it's right. Therefore, that parent then has access to that property so that they can take care of those children. What becomes very complicated, however, is when you pass intestate and you have children who are not children of your spouse that's alive. I've seen situations wherein people die without a will, without a valid will, and they're on their second or third marriage. And for each step of the marriage, there is a child or there are children. And what that does, you have a situation where the ex or the ex, two X's down, come in to the estate and now is dictating to that spouse that you have now built a home with for 20, 30 years. And those children are coming in and they're trying to put your loved one that's currently grieving, that may be elderly, out of the family home. I've seen it. It can be one of the messiest situations, and therefore I always say, even if you're married, please have an estate plan. Please have a will. Do not pass intestate, because you're leaving a legacy of grief. You're going to leave a legacy of torment, and the situation that you're leaving your family in could destroy all of the good feelings that you may have fostered during your lifetime. If you pass intestate and you have children who are not children of your current spouse, then those children will be takers in your estate, even if they're estranged, even if you have no relationship with them. Those children will take in the estate. That estate that you and your current wife worked for however many years to put together is now in jeopardy for children who may have nothing to do with you when you were alive. And children who may have, and I say children, these may also be adults. So people who had no interest in you while you were alive now come in and are seeking a share of the estate. And guess what? The current laws in Texas allows them to have a share in that estate. And so if you do not have a will, or if you were one of the people who went online and just downloaded something and wrote it, and you didn't follow the actual formalities of a will that Texas law requires, you may be doing lasting danger, lasting damage to your family and to the relationships that you're hoping to leave. So let me talk more about a situation when you pass intestate, when you die intestate. You pass intestate and you have accounts that are out there. Your spouse that's alive, unless you left that account in a certain way, unless you were joint owners, has to go to the probate court in order to access those funds, to do the simplest things, in order to pay the mortgage on the house, in order to bury you. So while you're sitting there, you're laying there in the morgue, that person, instead of grieving for you, will have to go to court to get your estate probated. They have to get an attorney ad litem to come in to say, yes, this person did list the heirs properly, and that entire situation, which could have been pretty fast, could have been a situation where everything is handled, where everything is smooth, where your family can breathe and grieve. It has now turned into something that's heartbreaking, that's complex, that can be tumultuous and cause severe strife in your family. I want to give you a personal tip. My grandfather passed intestate, and I can tell you that my grandfather passed about 20 years ago, and he was a great man. But I cannot think about his passing without thinking about the cloud and the strain that my grandmother went through because he passed intestate. Plan for your estate. It is one of the most loving things that you can do for your loved ones. If you want to learn more, please visit us at www.brianfagan.com and learn more. We're looking forward to seeing you.